the broadcast by the sole administrator of Rivers State calling for cooperation to restore peace, security and stability is eliciting mixed reactions. Already, Ibas, who has pledged to be apolitical in the discharge of his duties, is beginning to play host to a retinue of guests. Arise correspondent Andy Omano reports.
A day after assuming duties as sole administrator and delivering his inaugural broadcast, retired Vice Admiral Ibas is beginning to play host to dignitaries in Government House in Port Harcourt.
Your Royal Majesties, the primary mandate of my administration is to restore law and order in the state. For too long, our people have been held hostage by crisis, instability, and the actions of a few who prioritize personal gain over the collective good. I think this must stop. Rivers State is not just a geographical entity. It is the heartbeat of the Niger Delta and a critical contributor to the national economy. We cannot afford to allow lawlessness, sabotage, or threats to our national assets to persist.
It has been 3 days after the declaration of the emergency rule in Rivers State, and some of the early callers is a delegation of traditional rulers in the state.
You have spoken very well in your address to us. We are the grassroots leaders who carry a message back to our various communities, our clans and kingdoms. We will wish you a very big success in your assignment here in the state.
Meanwhile, the administrator's first statewide broadcast is continuing to elicit reactions from some residents of Port Harcourt.
As a military general, definitely issue of security is on his palm that he will be able to handle, but with the cooperation of all in the state. And there is nothing that is good for everybody in this state today better than for us to live in peace, peaceful coexistence.
There are a few things about the speech that, I have a few reservations on, and that is, for me, what is central, in the speech. One of what we saw is that the speech communicated hope, but the hope that it communicated was hope reversed. It was a speech that was heartbreaking.
The sole administrator, who pledged to be apolitical in the discharge of his duties, said he has already given directives on specific actions to be taken after his inaugural State Security Council meeting, while tasking heads of security agencies in the state to remain neutral and respect the rights of citizens.
There will be no room for lawlessness, no space for violence, and no patience for actions that threaten our collective well-being. We will not act arbitrarily, but neither will we hesitate to enforce the law where necessary. Let no one be in doubt. We will uphold justice and fairness, but we will also ensure that civil order prevails.
For now, the Rivers State people are waiting with bated breath to see how the new sole administrator, whose appointment has been one of the most topical in recent national political discourse, would match words with action. From Port Harcourt, it's Andy Omano, Arise News.
Well, Rivers people letting their feelings show. Meanwhile, we are now being joined for a conversation on the likely legal and political implications of President Tinubu's state of emergency on Rivers State by Abiodun Owonikoko, the senior advocate of Nigeria, with us. Sir, can you hear us clearly?
Yes, I can. Good morning.
Perfect. Good morning. Right. Thank you so much for joining us on the show. So again, welcome to the morning show. We're beginning this conversation just with how you would assess this issue against several measures. Number one being the constitutionality of President Bola Ahmed Tinubu's decision. Second, the legal standing of the appointed interim administrator. What legal standing does he have? Is his position constitutionally recognized? And three, the role of the legislature in all of this. Of course, with separation of powers, there are different arms of the government. So what is the role of these different arms of the government, and what is our reality as it pertains to the separation of powers in Nigeria?
Thank you very much, Kashi. It's a pleasure to be with you this morning. I would like to start with a word of hope and word of salutation to the drafters of the Nigerian Constitution. If you do not relate back to where we were in 1962, nobody will have a better appreciation of Section 305 of the 1999 Constitution. And so, in the 62 Constitution, which was tested, it led to an imbroglio because the power to declare emergency was vested in the Parliament, and the Parliament was required to have 2/3 majority to declare emergency. Now, the experience was that when that happened, the National Parliament declared emergency and enacted legislation to guide the administrator of the state of emergency in a divided Parliament. And that led to all the other things that eventually accounted for the collapse of the First Republic. The wise men who drove the 1979 Constitution that was recalibrated in 1999 learned from that and decided to diffuse powers with regards to declaration of state of emergency between the three arms of government. Rather than have the Parliament subjected to democratic debate before declaring emergency, they gave the initial trigger power to the president under the 1999 Constitution. But that power is a power that is exercisable for a limited period in order for the other arm of government, which is legislature, to review and then share the intelligence to determine whether there was a good reason to declare a state of emergency. So in 305, the president, once is satisfied based on relevant consideration, including security report, that a situation has arisen to warrant his proclamation of state of emergency either in the whole country, in a part of the country, or a part of a state, will then issue a proclamation that will be gazetted. But you can only do that and enjoy the exercise of that power for not more than 2 days if Parliament was in session. So you can see the beauty and the wisdom behind 305. So if a president did not do his homework and just assume that Parliament will see things his way, he would disgrace himself within 48 hours, because after 48 hours, if he doesn't get approval of Parliament, that proclamation will automatically terminate. And that will diminish him. So the idea behind distributing this power is to ensure that great consideration goes into that weighty decision. And you assume that if you are going to need the Parliament to have 2/3 majority of all their members agree with you to take certain steps that will more or less suspend certain provisions of the law, you have to do your homework. And I think this has worked out perfectly this time around. Contrary to what a lot of people are saying, people do not realize that today now, it is not the president's order that's in force now. It is the approval that Parliament gave that order by 2/3 of all parliamentarians in the Senate and in the House of Reps. Now, people have forgotten that there was a case in 2003, which is the case of National Assembly as a president, where the issue of special majority to certain decision of Parliament was considered. And the Court of Appeal in that case held that for 2/3 threshold to take decision of Parliament, it is not by simple majority. And they specifically stated that for the House, what they would need is 240 of the 360 members, and for the Senate, 73 out of 109. People have forgotten that this has been determined long ago, and the special majority must be majority of all members. So I believe that what has happened so far, the executive has done his own part, The parliament has done its own. What is now left, if need be, is for the judiciary to intervene. And the judiciary has a policy of respecting each of the other arms of government in their own spheres of influence. The decision whether to declare emergency is not a judicial decision, it's a political decision. That's why you can subject it to vote. If the country is going to collapse, you can't go to God to get an injunction against war. You can't go to God an injunction against a breakdown of law and order. So it's an executive function that will be triggered. So I believe that reason has prevailed and the Constitution has worked perfectly as intended in this instance. Whether the decision to now declare emergency is an abuse of power or not is a matter for the court, if so invited, to determine.
All right, SAN.
That is with regards to the declaration of emergency.
Okay, I hear you loud and clear, and I get your point as to the procedure that was taken and how the affirmation from the National Assembly now means that it has somewhat shielded the president from direct attack. But a lot of people may not agree with you. A lot of people will say that for you personally, you said that the Constitution has acted, has played out as intended. But then people will say that what happened in both houses, the red and the green chamber, will that pass, in your own opinion, for what the framers of the Constitution actually intended? In the House, it was a vote voice. And people are saying that you can determine 2/3 of the House by vote voice. And that it would have been a lot better if people knew how each of the parliamentarians, each of the House of Reps members, and each of the senators voted. For the Senate, they even had to go into a closed-door session. We didn't see much of robust discussion. And therefore, people feel that it was an acquired endorsement from the National Assembly. What are your thoughts on that? And then secondly, when you say that it's now left for the court to interpret, what do you say to those who say, yes, the president may have the powers under Section 305 of the Constitution to declare state of emergency if certain conditions are met. But then does he have the power to appoint either an administrator or a sole administrator, or even an head of interim government for that particular state, given the fact that the Constitution is clear as to how a governor can be removed? So is a suspension of a governor, as the president has done, constitutional, in your own opinion?
Thank you very much. Let me address the first. The first is with regards to the procedure adopted by the Parliament to approve the proclamation. And that's why I started the authority of the National Assembly and Federal Republic, the President, in 2003. I would be surprised if, upon a challenge in court, and it is established that the procedure followed did not establish the required quorum. The required quorum to approve the President's proclamation is 2/3 at the minimum of the Senate and House of Reps. And I believe that, though internal affair of the Parliament, if evidence is produced to show that the Parliament did not have the required quorum of at least 2/3 of the House of Reps and 2/3 of Senate, it is possible to strike down the proclamation. So those who are going to court will have their work cut out. How do they establish the quorum? Because it's an official function. And Parliament will then be the one to provide to the court the register and attendance of members. Once they have 2/3, you already assume they have a quorum. But whether the entirety of the 2/3 voted, that's another issue. So I don't want to comment too much on, but I know that because the requirements are all members, that's what the Constitution says. For the purpose of approving a proclamation, is 2/3 of all members of both chambers that should take that decision. 2/3 of all members mean at the minimum there must be at least 2/3 of their.
Yeah, but in taking the decision, SAN, in taking the decision, will a vote voice suffice in taking that decision?
Well, a voice may suffice because Parliament has the prerogative to determine the manner in which they decide their matters. But if you are able to show, I think the only chance of voiding that procedure is to show that not up to 2/3 members sat in both chambers. If you cannot show that, and they can show that 2/3 of members were in attendance, and they all endorse the decision, it's for the Parliament to decide what mode they will adopt, as at now in Nigeria, to take a decision, whether by a voice vote or by a division. If they don't take that and decide to go by a vote, you will have an uphill task to show that not all members supported. As it is today, you can as well assume that the decision to approve was unanimous until otherwise shown in a court of law. That's for that. Now, on the question whether the president can suspend a governor, the president can suspend a governor who is the source of threat to law and order within a state. Because what the Constitution has done is in Section 5, Subsection 3, people have not read this Section 5, Subsection 3 of the Constitution, that the executive power of a governor of a state shall be exercised in such a way as not to impede or prejudice the exercise of the federal power. Where a governor, as appeared to be the case in Rivers, given the judgment of Supreme Court saying that there is no government in Rivers State because the two arms of government were no longer functioning as required by law, the president does not require much more than that. Now, there's a range between law and order and security. Where the conduct of governance is in breach of law and order, even if there's no breach of security, it portends a big danger. For instance, transactions have been going on for the past 1.5 years in Rivers. Appropriation was not done. Contracts were awarded. Government was committed. If at the end of the day, the determination of whether government was functioning legally were to go against the state, what happens to all those decisions that will have been taken in the last 1.5 years? It's a serious matter. Now, in addition to that, the president cited the question of threat to federal assets. It's one of the conditions under which president, even without invitation by a governor of a state, can intervene and declare a state of emergency in a state if the federal assets in that state are at risk, imminent risk. Now, in this case, there was cited the case of pipeline, whatever going on, being bombed and all the rest. What they mean by federal asset in Nigeria, if you understand it in Nigeria, really, the asset of federal government in any state now is about natural resources, really, apart from physical building. And if you are talking about Nigeria's mainstay of economy is oil and gas, if there is a threat of pipeline being blown up, whatever, that is a federal asset being threatened. And that's the whole idea of resource control, because these assets are vested in federal government as against in the hands of those who are supposed to be the natural owners. So if there is such a threat, the president can intervene. Now, it does not require the president to suspend a governor. If the threat in a state actually is a threat that is meant to overwhelm the government of the state, the president needs the government of the state to actually contain it. But where the threat itself is coming from the government of the state that should collaborate with the federal government to address the threat, then that is the first source of threat that should be managed. So the president cannot remove a governor, but he can freeze his executive powers. So suspension is a freezing action, not a removal. Thirdly, you ask whether the president can appoint the sole administrator. Now, people have been looking at the Constitution and they are saying they are looking at 188, he didn't talk about. Now, go and look at Section 5, Subsection 1 of the Constitution in terms of how the president carries out his functions. And also go and look at Section 318 in terms of what is called power, what is function, what is public service, and Section 318(4), which says that to interpret the Constitution, you have to have recourse to the Interpretation Act. That is inside the Constitution. So it's not just by merely reading section of the Constitution. You have to look at how is that Constitution to be interpreted based on Interpretation Act. Interpretation Act says that where power is given, then functions and obligations and responsibilities and benefit go with it. And if a president, if you look at definition of public service of the Federation, it includes any person who is given capacity to act on behalf of the government. So the president's appointment of sole administrator is not to replace the governor. It's to execute his executive power in the state for the purpose of addressing the question of breakdown of law and order. So, and that's why I was a bit worried when I heard the sole administrator saying that this is my administration yesterday. The sole administrator does not have any administration. The governor of Rivers State remains Governor Fubara. But his powers are frozen now, pending when the danger that the proclamation is meant to address is taken care of. So the soldiers should be very careful about how he start talking about his administration. If he's talking about administration, then that may be one of the things that may be used actually to strike down this proclamation. Because if those who are threatening to go to court can establish their locus and they can bring material showing that the man is operating as a governor. For instance, I don't see a sole administrator being able to sign a CFO in that state. That's a function constitutionally vested in the governor of a state, and that's has nothing to do with law and order. All powers that will be exercised by the sole administrator must be related to addressing the challenge which led to his appointment. It cannot include acting and appointing commissioners as if we are in the normal course of event. It's an extraordinary situation, and his appointment is simply to address that extraordinary challenge.
Will it sorry, Kachi, just quick one. Would that function include spending the federal allocation of the state that was suspended under Fubara, but has now been released to him?
Yes, that is very correct. It will include it, because the order of the Supreme Court was that the governor could not spend money without appropriation. In an emergency in which there is an extraordinary intervention by the federal government in terms of the president appointing a delegatee of his authority, the funds of the state is like commandeering assets in a war situation. I'm sure you remember during the COVID era, even President Trump commandeered a lot of assets, even took over factory and said they should be distributing. In a situation of emergency, ordinary emergency, the fund of the state is available for the purpose of running the affairs of the state. He is not operating as, that's why I said they must be careful. If he considers himself a governor, then he will need appropriation. Then he will then need to go to National Assembly in the meantime to get appropriation. But it's not a governor. It's just a delegate of the power of the federal executive authority that has taken over affairs in the state to address the challenge. So the federal government can release funds of the state to him to address that challenge. I mean, the same reason why police is not under the state control. State governments provide vehicles, support police operation security in their state. So as at now, for the proper functioning of the state, salaries of workers have to be paid. The normal functioning of government institutions must continue. So it's only in that respect that he can do it. Don't forget, however, that he is supposed to prepare regulations which Federal Executive Council will approve and which probably the National Assembly can intervene in terms of how he goes about this. I don't think he's going to be doing it in an arbitrary version. And I listened to some of his pronouncements yesterday. He appreciates the duty of accountability.
Okay, so, SAN. Now, just as we wrap this up, everything we've spoken of is based off of that declaration of the state of emergency. But some people will argue that truly the situation in Rivers State, did it warrant a state of emergency? And I'd like you to speak to that, the declaration itself that has led us to now analyzing the sole administrator's powers as against the powers of a governor. You mentioned some vital sections of the Constitution. So looking at 180.305, 5 subsection 3. And then is there a part of the Constitution that also stipulates how long this suspension could be and how long the state can survive without its governor? Because as you rightly said, the sole administrator does not have the powers of a governor. How would that then affect the people who require a governor for the state to survive?
Thank you. The first question, the prerogative and the decision whether there is a state of emergency to declare a proclamation is that of the president alone. He might do it wrongly, he might abuse it. If he does that, they expect that the parliament, in reviewing his decision, will take a political decision by vote, whether to go along with him or not. The idea is that, like Steve earlier noted, the idea is that parliamentarians will go back to their constituents to have a feel of what they believe about this. It's a political decision. It's not a legal decision. That's why I was worried when people started saying it's not constitutional, it's legal. It is constitutional, but it's a political question, and courts do not answer political questions. Anything that is within the remit of the executive, the court will not second-guess them unless it can be shown that they have exceeded the authority. Anything that's within the premise and remit of parliament, the court will not intervene. But the court will intervene after that process is concluded, which is now. Now there is a proclamation which has passed through the process of political decision. The court can now determine whether, given materials that may be available to the court, including, in fact, summoning the executive to provide the security report, which might be reviewed in camera in court without being exposed to the whole world, so that the court can decide whether, in this situation, there was a warrant for declaring for proclaiming a state of emergency. That is part of what the court can look into as at now. That is on the question of whether the president had it right. But the fact that he got the parliament to agree with him speaks a lot in terms of the wisdom and correctness of his feeling, his judgment. Because what you have to do is so the condition subsequent to declaration of emergency is that you should get the buy-in of parliament. If you didn't do your own work well, and you don't forget, the Senate had an executive session. What they do in that session is to look at, you remember that Senator Siriakiskin was the one that drew the attention that they ought to have an executive session. At that session, security issues that cannot be publicly exposed will have been considered. And despite that, they went ahead and approved. You might have reason to believe that some other political consideration on that don't play their part. But that's why the process has been made so rigorous, that if all the majority of people that you have in government think this way, then we probably deserve the people we have in government. And then we are left with trying to test their decision judicially in court.
All right, let's say just very, very quickly before we let you go.
You asked me about
yes,
other provision of the Constitution.
There was one more.
Please,
yes.
let us get one thing. I think you asked.
Yes. Please go ahead. Please go ahead.
The Constitution need not. The Constitution did not provide elaborately for how to manage a situation of emergency. That's why it's an emergency. In fact, the Constitution yields the ground to discretion, where the normal functioning of states is not possible. So that the actors in government will not be constrained by the need to say they are doing things by the book. That's why they are called extraordinary measures. That's why they are called extraordinary measures.
All right.
And it is actually for no more than 6 months, not more than 6 months. It could be shorter. If the president tomorrow decides that there is no basis for it anymore, he can by gazette terminate it. Parliament on their own, by simple majority, now, get the difference now, by simple majority can also terminate it before the end of the 6 months. And I think the parliament eventually put a caveat that the president need not wait till 6 months. One other final thing I want to say is this. If the president, we should understand the need for statecraft. If the president within 3 days could rally around 109 senators and 360 House of Reps members to do what he wanted in terms of legislative approval, can't you see that something was wrong with how Governor Fubara went about his problem with the parliament? That for almost 1.5 years, he fell out with them and he could not rally them. He could not get at least 11 members to switch to his own side. For 1.5 years, something is wrong. Maybe this is a learning curve for him.
Yes.
This is period to reflect and see things he can do better.
All right. Just before we let you go, the Emergency Act of 1961, was it ever repealed, or is still just in abeyance?
Well, it is impliedly repealed because it is based upon section 65 and 70 of the 1960 Constitution, which has been repealed.
Yeah.
And that section arises from Parliament itself declaring state of emergency.
Yes.
I told you, President doesn't declare under that. It's the Parliament that declares emergency. And that law is now to regulate the executive arm in how they execute it. In Nigeria now, it's the President that declares emergency. And then he gets ratification of Parliament. Okay. So that law, in effect, is no longer operational.
All right.
You can have implied repeal of the law without it being specifically done by a legislation.
All right. AJ Owonikoko, SAN, we want to thank you so much for the brilliant submission today on The Morning Show. Thank you indeed.